You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention. You shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. We have one case on the docket today, in re joint resolution of legislative apportionment. Mr. Smith.
Good morning, Your Honor, and may it please the Court. After the Court was forced to invalidate the last Senate map, it sent it back to be redone. Unfortunately, the Senate again failed to come into full compliance with its constitutional obligations under Article 3, Section 21. In fact, it did not do nearly enough to eliminate the glaring favoritism for a political party and for incumbents that is still a feature of the new map that is now being reviewed today.
Well, could we address the scope of what the Senate was obligated to do upon the judgment being entered? I think that you and the Florida Democratic Party take the position that the Senate had to redraw the whole map?
Absolutely, Your Honor.
Well, reading the conclusion, reading the entire opinion, it would seem that, speaking for the person that wrote it, that it was pretty clear that there were certain districts that were specifically invalidated. There were other districts that where challenges were specifically rejected. And I'd like you to address, whether you call it res judicata law of the case, whether if we were to look at districts that were unchanged, which are 14 of the 40, and where challenges were either rejected or the burden of the challenges weren't met, how would that be fair to the Senate? And fairness should be part of this whole process.
Sure. I think there are two elements that you need to keep in mind here that support the proposition that the whole map is now before you. One is, of course, the constitutional obligation that the Constitution puts on this court, which is to assure, regardless of what challenges may or may not be brought, that the whole map is constitutional. That was your duty the first time. It continues to be your duty under Section 16 of Article 3 this time. Even if we weren't here today, you would have that same obligation to review the map and make sure the apportionment is valid, to use the language in the Constitution. The second point I would make is that the court did not simply invalidate 8 districts. The court gave additional instructions to the Senate that require a much broader review. It said, for example, that the Senate's understanding of the requirement of respect for political and geographic boundaries was completely off base, that they had to go back and start over on that. And therefore apply that new lesson to the districts that it would be presenting to the court again.
Doesn't your argument here assume that we did not look at the other districts that were not invalidated? It seems to me that if we said that there were certain districts that were invalidated, we certainly realize that if you're going to straighten that out, that some other districts may be affected.
Sure.
You would agree with that, correct?
Yes.
But if there were districts that would not be affected by straightening out those that we thought were invalid, that we said were invalid, why would we now want to go back and look at others? That just doesn't, to me, resonate. We looked at the entire thing before we had the opinion in mind.
Right. I understand, but I think it's important to understand what else you told the Senate to do. In addition to fixing its understanding of respect for geographic boundaries, you told them to review all of the minority districts to make sure that they are not excessively violative of the Tier 2 requirements, to go back and do the minority districts over to make sure that that wasn't a problem. That was in addition to the 8 districts that you talked about, that they had to go back and do this functional analysis and review that.
Why don't you give us, because you certainly have limited time,
yes,
an example of an attack on a district, because you even haven't attacked all the districts.
No, by no means.
Okay. That was unchanged, but either that a different argument is being made, different evidence has now been developed, that now shows that what was previously valid can't stand if the jurisprudence about this is going to be equally applied.
I would just preface this, and I will do that, Your Honor. We have new lines that are the core of what we're challenging here in Northeast Florida and in Orlando. But an example of what you're asking for would be our discussion of the Tampa Bay region, which is unchanged. But given the court's focus on the Tier 2 requirements and particularly respect for compactness and geographic boundaries and political boundaries, we have brought to the attention the fact that there are 2 different districts that cross Tampa Bay there, not just the minority district that needs to do that to avoid retrogression, but a second district, District 22, which essentially gratuitously crosses the county line and the bay. It is essentially a twofer for violating Tier 2 because they do both. They both disrespect the boundary and disrespect the geographic boundary.
Now, were those districts that were challenged last time by the coalition?
There were some related challenges in the neighborhood, what is now called District 17. I believe it used to be called District 15, Senator Norman's challenge. But that particular argument about crossing the bay with respect to District 22, what's now called 22, I'm not actually sure what it was called last time, was not, I don't think, brought by any of us. What we did is we challenged the whole map, talked about the process, the fact that they went to all the incumbents and asked them what they wanted, and then we had a very short section in our brief that gave some examples of what the results were, but we didn't view it the way we now do, given what we've learned from this court about.
Well, if we don't accept your argument, you want to go to the challenges that are new challenges.
Happy to, Your Honor. I think Exhibit A is what happened in Northeast Florida. Northeast Florida, you recall, had that rather ugly, sprawling District 6, which had the tentacles going out to pick up African-American and Democratic population coming down from Duval and going through a number of other counties. And the court said, in addition to being non-compact, that district was, quote, indicative of an intent to favor incumbents and a political party. And it sent back to draw the district which the Senate essentially drew, which was a version of what we had proposed, a Duval-only district. Now, however, what they did was they set out, having to put the district in Duval County alone, to find a way to make sure that every other district in that region of the state remained Republican-controlled. Exactly what they had achieved with District 6, they decided they would try to achieve it without District 6, and they did that. They drew the districts in such a way that every other district up there, 4, 5, 6, 7, are Republican-leaning or very likely Republican-held. And this is one of the real problems with that was a linchpin of their ability to do that was the way they divided Volusia County, and in particular divided right down the center of the city, Daytona Beach, Florida, and its African-American community, a very strongly Democratic base, which was divided so that both District 6 and District 8 would remain Republican-controlled.
Now, their argument on that, as I'm sure you're familiar, is that when they redrew District 6, without taking population from somewhere, that they had to draw in population in order to equalize the population. And their rationale was that they didn't want to split Clay County, and they therefore chose to split Volusia again and split Daytona Beach.
Right.
So the argument is, and this is, I think this area is a critical, I think this is probably, in my view, your strongest challenge, is that this was a reasonable legislative discretionary decision. On a facial review, how do we not say that that's a reasonable alternative?
As this court indicated last time, you look at the alternative maps and find out whether, in fact, that was the only choice they had. And our map, as well as the Florida Democratic Party map, show that you didn't have to split Clay County to keep counties whole.
Well, your maps they sort of a trade-off. You take Putnam, as Putnam goes into 6 and Clay goes into 7. Is that?
It's the other way around, actually. I think we put Clay into 6 and Putnam into 7.
That's what I meant. I'm sorry.
And keep them both whole.
Now they say, well, you didn't bring this to their attention, you, the coalition or the Democratic Party, while they were considering the redrawing in this very short time frame.
We had a map that they had, which was part of the last proceeding. We have some variations on the map, but the fact of the matter is they have a bunch of counties. They say they played very carefully with them, and they were either required to split Clay County or split Volusia County from the north, and that's simply not true. The second problem with that argument is you didn't have to split Volusia County in precisely that way. The mark of a gerrymander is very clear. When you come down into the county, you swerve down and then come right into Daytona Beach. There's 1,000 different ways you could have split Volusia County if you felt you had to, although as the maps show, you didn't have to from that.
But now okay, go ahead.
My question to you is, what violation is there, however, if they made a choice of splitting Volusia versus splitting Clay, what of those, is there a Tier 2 or Tier 1 violation here by splitting Daytona Beach.
Well, they didn't make a choice between splitting one or the other. They didn't have to split either one, is the first point I would make, Your Honor. The second, so that they have gratuitously split a county. Second of all, they split a city. So that's a violation of Tier 2 as well. And the way they split the county and the way they split the city is, I submit, objective evidence in a facial review of intent. And we've given you a map that in this region of the state has two 50-50 competitive districts. They have a map in which every district up there is 45-35 Democratic in terms of the prior election results plugged in. So you have, I think, a very clear effort to find a way to make sure that they cancel out Democratic votes in that region of the state. They tie Gainesville up to Clay, which is probably the most Republican county in the state. They split Daytona down the middle to put it into two districts so that neither one of them can end up being competitive for the Democratic Party. And that is, I think, no different from the kinds of things this court invalidated last time. It is, I submit, as good an evidence of violation of both Tier 1 and Tier 2 that you could find.
Do you think do we look at the history of this area in that Daytona had been part of the invalidated District 6? It was previously, for the last 10 years, had been there. And I think before that, although it wasn't part of that district, Daytona appears to have been kept whole as part of a different district. And this issue that you said, which is that we were critical of the packing of all these Democratic black communities into one to essentially dilute the vote. But now what they've done is that they've dispersed the African American communities into three different districts. In other words, is that something? Where does that fit in? And that's it's not a voting. It's not a Section 2 or 5 violation, and no one's claiming that. So where does that fit in, that these were African American Democrats that are being affected? Does it matter versus that it was white Democrats? Does it at all?
No, not really, Your Honor. The argument is political here, not racial. I think, though, you have a history of using race as a pretext to create a political gerrymander in this region, and I think what you see, again, is not using race as a pretext, but dividing a racial area as a means to accomplish the same gerrymander in a different method. I think the fact that they had an intentional gerrymander there last time, as the court said was likely or indicative, is not uninformative of what's going on the second time around. And you have a map which shows that there are plenty of competitive districts that could have been drawn up there. They just didn't want to do it. Let me turn, if I might, then to the Orlando region, which was redrawn at the direction of this court to eliminate what was old District 10, which was Senator Gardner's district, which was the strange appendage that came in to grab his residents and then take him through a narrow corridor out to the west to safe Republican turf west of the Orlando area. The new map does essentially the same thing with a mirror image. It takes the same area of Orlando, a white, relatively affluent part of the Orange County area, wraps it to the north of the Hispanic district instead of to the south of the black district, and takes them out to the east to territory that goes all the way out to the Atlantic coast, taking up a big chunk of Brevard County to give him safe Republican territory. So you have a situation, once again, where through a non-compact district, a powerful Republican senator is given Republican constituents who have nothing to do with his metropolitan area where he's located. And the reason I think they did it is essentially the same as the reason they did it last time. The natural way to draw that area into a district is to go north in a compact way, as our map does. But the problem with that is you would have had a real pairing between Senator Simmons and Senator Gardner rather than what they claim to be a pairing, which isn't really a pairing, which is the way they've done it this time.
Now, on it's hard to keep track, but on the alternative plans, there are concerns, are there not, or should we have concerns with District 12 and 14, which one is a black majority district and the other has become a Hispanic majority district.
Well, they're not actually majority districts, Your Honor, but
they're influence districts.
Well, and they're probably somewhere in between, more like ability to elect districts, opportunity districts.
How does your alternative plan affect those two districts?
Well, the black population in District 12 and Hispanic population in District 14, I think, is slightly lower in both cases. We did that, but particularly with respect to 14, the Hispanic district, in the service of compactness. And because there is no retrogression concern as to 14, because there was no prior Hispanic district, ours is much, much more compact than theirs, and will grow into a Hispanic district over the next few years. The Hispanic population, primarily Puerto Rican population in that region of that Central Florida, is skyrocketing. And so while ours is slightly lower than theirs at the moment, since there's no legal justification for the non-compactness, no retrogression or Tier 1 argument, we think that the right reading is you keep it more compact and allow it to become more and more Hispanic through the decade, which it certainly will. But do you think, again,
here is something that is maybe different for up in that region. Is it legitimate, though, as a consideration that if you look first at compactness and population equality and the Tier 2, but don't your plans, they do take District 14 below a majority?
Well, it's never been there before. We don't take it below.
So that's true for Section 2 or 5, but just like there may be some arguments about the Northeast Florida area, that there are some racial issues that are important to consider where the blacks are placed. Don't you also, isn't there also a legitimate interest in keeping and making District 14 Hispanic, or is that impermissible consideration for the legislature?
Well, to the extent it has to be rather severely non-compact in order to get the population slightly higher, I don't see a legal justification for that either under the state constitution, because there's no retrogression argument, or under federal law, because federal law certainly doesn't require you to create a new minority district which is very non-compact and still well below 50%. For those two reasons, Section 2 of the Voting Rights Act just has no relevance here.
And what about District 12?
District 12 is also not a Section 2 district. It's not a majority district. There might be a retrogression argument, but I think in that case the difference is so small that ability to elect still exists in the way that it continues to exist up in Duval County in the African American district there. But obviously, if the court wants to disagree with us about that thing, it would be a simple matter to get the District 12 back to where we didn't do anything major to it. The line could be slightly adjusted. There was some concern in the brief about one particular town that somehow got across the line into the majority white district. Those things could easily be adjusted. I don't think that that's a basis for rejecting our challenge. It has nothing to do, frankly, with our challenge to Senator Gardner's district, which is non-compact in the extreme, simply to avoid, to make sure that both Senator Simmons and Senator Gardner have districts to run in. That's what it was.
Well, you take something, though, that concerns me, which is we certainly looked at incumbent pairing. But now you take that after these were drawn, Senator Simmons announces he's going to move. Now, politicians move all the time when districts are redrawn. From my limited experience of what happens or what you hear happens, how do we take something and say that was done to where they're not living there at the time of the drawing and say, well, they must have known that Senator Simmons was going to move? I have some difficulty in this court making that kind of a leap.
I understand, but you have to take into account the fact that they drew the non-compact district for Gardner that otherwise would have really paired them and taken over that same territory into Seminole County. The fact that Maitland, where he lives, is now just very close to the line. And according to the press, I just read the papers like you do, he has lots of properties up there, and he represented it he lived there for 16 years. I mean, there's an awful lot of apparently objective reasons to think that this is as unstressful a pairing as you could possibly experience as a politician, Your Honor. And it's also interesting to note that it's the only one they even claim in the entire state of Florida. Unlike the House map that this court upheld, which had numerous pairings, they still seem to be making sure that everybody who's got an opportunity to run again will have his own place to go. And, whatever else you say about what you can or can't infer, Senator Simmons has a place to go. There's no doubt about that.
Mr. Smith, you're now in your rebuttal time.
Okay, I will, if I might then reserve the balance of my time, and I appreciate the tip, Your Honor.
May it please the Court. My name is John Mills with Boies Schiller Flexner. I'm counsel for the Florida Democratic Party. Co-counsel are Neliver and Joe Hatchett with Ackerman Centerford. I'd like to reserve 5 minutes for rebuttal. When this court issued its historic opinion, it was very specific about several things. First of all, it was specific that the entire state must be valid, that the plan must be consistent. No individual district or individuals in Florida have a lower right to a valid district than any other individuals. This court also placed a major priority on compactness, justifiably. The compactness symbolizes fair districts, the avoidance of gerrymandering for political or other purposes. In defining compactness, this court went through a series of tests. Was the district visually compact? Were there objective standards, either
I know, but the holding, and again, this is, to me, it said we have held, and we said districts 1, 3, 6, 9, 10, 29, 30, and 34 are constitutionally invalid. The legislature should remedy the constitutional problems with respect to these districts, redrawing these districts and any affected districts in accordance with the standards defined by the court. It seems that if the court intended that the entire plan be redrawn, that we should have said, in fairness to the whole process, and all the other districts, whether we've upheld them as against the specific challenges, should be looked at with regard to these challenges, even if we didn't challenge it. It shouldn't. I mean, it's just so not there. And I think there was a choice that the court had to make about the scope of what it was going to be doing, and it just doesn't seem like the ones that were unchallenged and don't have to be again, there can be an argument that, listen, they, in certain parts of the state, like the Plant City, they just changed all sorts of districts, but then they minimize what they were doing up in Northeast Florida. So there's some inconsistency there for looking at the challenges. But as far as saying that every district, even the districts that were not challenged or upheld, have to be looked at, I've just got some concerns about that.
Well, I understand that, and frankly, you have total discretion. This court reviews to determine what's valid and invalid, and if you look at it and you thought it was valid before and you think it's valid now, then it's valid.
But can you
now,
can you give an example, I asked Mrs. Smith this, of a district that stands out as being, if the court had applied the overlay to that district, and if we had thought of that challenge, we would have made that challenge, and we're making it now.
Now, but if I may just make one remaining argument in terms of fairness and process. Res judicata means something was decided precisely as it was. Many of these districts were changed, and you know that, and you know which ones. And also, there were some conclusions this court made about arguments that can now be made. This is the first time we have an opportunity to look at your opinion and apply it. Henceforth and forevermore, there will be that opinion. But today is the first day. I'll give you an example, District 32, which previously you said the Florida Democratic Party and challenged, it was 25 or 26, I think. But did not provide an alternative. And in your opinion, it became very important to show that one of the tests for compactness, visual, objective, appendages, is there an alternative that doesn't diminish minority rights? Now, 32, by the way, was slightly changed. So I think you can make this argument without even having to make the part of the argument that I'm making. 32 is extremely non-compact. It's the least compact district in the state. It appears visually, if you were going to try to justify it, that it is a coastal district. You rejected 2 coastal districts because communities of interest are not a standard. Clearly, this district is not justifiable on a Tier 1 basis. So by objective standards, it is non-compact, there's no Tier 1 justification, and there's an alternative that is substantially more compact. That is an example of an argument that was refined. The other area is...
I'm sorry, which one is 32? Are we down in South?
No, it's Marion... No, I'm sorry. It's Martin, St. Lucie area. It is,
Okay.
if you look at the map, it is a long, skinny coastal district that has a REOC score of 23, which is the lowest score of any REOC score in the entire plan.
Well, pretty close to District 8.
Pretty close to District 8, which I agree with Your Honor that is the other area that's clearly changed. And by the way, the REOC score in District 8 not only is low, it went down. It was previously 28, now it's 24. So the district was changed, and it was worse. And I understand the argument and the discussion about redrawing the districts. But as Mr. Smith was explained, it is possible to do what the Senate wanted to do, which is keep Volusia whole and keep Clay whole. And I think it's also important to understand that the splitting of Volusia was done with an alternative. There was an alternative offered on the floor to put Daytona Beach back whole, and that was rejected.
But that alternative did involve splitting Clay County?
It probably did. I think you'd referred to the minority question. There's no question that there are better options for minority members in the 6, 7, and 8 area than the plan. But the most important and central point is there's no Tier 1 justification at all. And according to your test and flow of argument, you go from is it compact and using visual objective standards, are there appendages, and are there alternatives, to then is there a justification? And with regard to that, I'll mention one more district. District 14. You started to discuss District 14, which the Senate argues is a Hispanic district. It is in their plan, and by the way, it is very non-compact. Let me suggest also that the test that you have done, a good example of the review of the test, a test for District 32 would be exactly what you did in Districts 1 and 3. There's no racial justification. The only justification was it was communities of interest, and they failed. That same test should be applied to District 32. And looking at District 14, there is a racial issue. There is a racial issue. So the question is, how do you address that? You address it the same way you address District 1 and 9. You said, is it possible?
You mean 1 and 3?
No. I'm sorry. 6, New Jacksonville.
All right.
New Jacksonville. The test that you implemented on 9, which was a very, very important test for precedential value, because it does say you're not locked in forever to percentages. Very important point. Very important point. And you say that a couple of different places. That simply a voting age population should not lock in an area. So you have to do a functional test. You have to actually look at 14. So 14 is at least of concern because it's very non-compact. So what is the justification? So the justification is we have a 50% voting age population, but you have to look at the entire situation. The entire situation is the Hispanic population is only 28% of the Democratic primary, and this is a Democratic performing district. The alternative, which is relevant, is 0.3% different. So the exact analysis that you did on District 9 should be employed on District 14. And that is, there is no significant difference in the ability to elect, but there's a significant difference in compactness. Let me briefly mention, because I do want to preserve my time, the issue of influence. This court previously talked about pairing of candidates. It also talked about core districts. Candidly, the most important thing to a politician are, who am I running against and who's voting for me? You directed the Senate to solve issues about numbering, they did. You directed them to solve issues about deviation, they did. These are the two most important incumbent-related issues. Now, there's no significant change in pairing. And you look at the core districts, they're substantially the same. You just have to make a judgment whether that change was significant enough. But those two issues together are an indicia of favoring incumbents, not necessarily partisan.
Do you know the percentage of District 13 that is currently represented by Senator Gardner? I mean, how much did he carry over into 13? That is the one.
I don't know, Your Honor. And I guess that's the district we're talking about, the pairing, right?
I think you're talking about 10 and 13, right?
Right, 10 and 13. Conceptually, there's an understanding that Simmons would move to 10 and that Gardner would be alone in 14. Now, 13. Okay, so
13, right?
13. So ultimately, that's one pairing max. When you look at automatic retirement, and then looking at core, there's a very interesting fact which the coalition pointed out and is re-mentioned in our brief, that if you look at the core districts for people who are actually running, they're much, much higher than for term limited. What does that tell you?
One of the districts that we haven't talked about is the plants. What happened with the Plant City situation, and there's an argument that when they made the change at the last minute on the floor, that the purpose was for two representatives not to have to run against one another, but looking at the alternative plans by both the Democratic Party and the coalition, you have them in different districts also, don't you?
District, what is that district?
I think it's 21 and 26, but it's the plants, it's that area where there's the argument is, I may be wrong on the numbers, it's the one that was changed on the floor to move Plant City into Hillsborough.
Mm-hmm.
And
this is the amendment offered by Senator
Latveller.
Yes, I think your statement's right.
So how do we, with that in mind, if you can't offer something that puts them together, first, I mean, then it seems to defeat the argument. The other part is, do we necessarily, if that district or that area becomes more compact and more faithful to the lines. I mean, I think we know Plant City is, we know certainly for circuit districts that, for circuits, that Plant City is part of Hillsborough for a lot of reasons. So on its face, it looks reasonable and it doesn't violate. If
it's smaller, then it's more likely that you will have.
Well, it doesn't violate the Tier 1, Tier 2 indications. It becomes more compact.
And I think that is the higher standard. I mean, the compactness is the mandatory standard. These are indicia which, in the first opinion, you said collectively.
So you don't. So do you have for that area? Can you offer anything else that would say, "Oh no, the court would"? You've carried your burden to show
that's not an area we chose to emphasize.
Okay.
So, in conclusion, for now, the overall plan has at least 3 or 4 districts that are very challengeable, either under your theories in District 9, which you did, which is 14, or the theories that you implemented in Districts 1 and 3, which should apply to 32, and to 8, because 8 has no racial justification. Thank you.
May it please the Court. My name is Allison Riggs, and I represent the Florida State Conference of NAACP branches. The Florida NAACP urges this Court to find that, based on undisputed statistical evidence in front of you in this record, Senate Districts 9 and 31 violate Article 3, Section 21 of the Florida Constitution because they diminish the ability of black voters to elect their candidates of choice. Despite voters across the state voting to create redistricting criteria that would maintain the hard-fought ability of black voters to participate in the political process, we have a situation where there's been a weakening with no offsetting benefit to that ability. Before I get into the specifics of those 2 districts,
9 is the Jacksonville one that stretched for miles and miles and miles previously, correct?
The Duval County
and
one.
So do we have to maintain the exact proportions that were there in the previous district? I mean, so doesn't the minority voters in the new 9 still have the ability to elect the candidates of their choice?
Your Honor, I would posit that the data in front of you actually shows that they do not. But first,
it's a majority Democratic district, right?
Exactly. And the problem is that without considering racially polarized voting trends, there's a flaw in that assumption that because a district performs democratically, it thereby enables black voters to elect their candidate of choice. The consideration of racially polarized voting trends are fundamental to the functional analysis that this Court described in its March 9th opinion. First and foremost, the U.S. Supreme Court said racially polarized voting trends is one of the relevant factors to determining whether there is an ability to elect. Second, the D.C. District Court opinion, the December 2011 opinion in Texas v. United States, which was cited by this Court several times in its March 9th opinion, noted that the first step in a Section 5 case is looking at racially polarized voting trends. This was the first court to examine the new post-2006 amendments to Section 5, which included that non-diminishment standard. That court noted that the functional analysis that it adopted was similar to DOJ's 2011 guidance, but it wasn't exactly the same, and its focus on racially polarized voting was one of those differences. The data that the court has in front of it that was part of the election data that my district builder included is not the ideal racially polarized voting analysis, and I'll talk a little bit more about that later. But it does provide enough indication of racially polarized voting trends for this court to find that there are objective indicators that because of racially polarized voting, black voting strength has been diminished to the point where the ability to elect is lost.
Now, you have pointed to the Meek, Christ, Rubio. Does that Senate race alone establish racially polarized voting? It's such a wasn't that it's a three-party with an independent. Isn't that that be speculation just based on that alone? And it was not anything that was actually brought to the attention of the Senate, was it, when they were doing the redistricting after the invalidation?
Well, as I understand it, they did have the election data the second time that the House had the first time. But the
House, I didn't think, because we used whatever the House had, that the Senate, that Senate race was part of what was in the House software. Is it your understanding it was?
It was certainly produced in the appendix to the declaratory judgment action. Two things. There's a wealth of jurisprudence that says racially contested elections are those that are most probative of racially polarized voting. We don't have a lot to choose from here. We have two. We have the 2008 presidential election and the 2010 U.S. Senate race. There's also a wealth of jurisprudence that says endogenous elections are much more probative of electoral behavior in a district than are exogenous. Now, both of these are exogenous, but one is a lot closer to the scale of the district that we're talking about, and that's the 2010 Senate race. And what we see in the 2010 Senate race, the reconstituted election results, is that black voters were not able to elect their candidate of choice if that candidate was African American. The Voting Rights Act and the Tier 1 provisions of Article 3, Section 21 can't protect the ability of African American voters to elect a candidate only so long as that candidate is white and Democrat. It has to protect the ability of minority voters to elect a candidate even when that candidate is African American. So we have a district where the will of African American voters who had the ability to elect previously is now being frustrated by white Democrats who will not cross over to vote for a black Democrat.
And that's established as to Southeast Florida, that you would take the Meek race. Do you have the same information for Southeast Florida?
No, Your Honor, there is a different result down there.
So what's the result down there?
Meek was the top vote getter down there.
And really what the NAACP is asking us to do would be to put Christmas District back where it was and eliminate the one additional Democratic district that occurred as a result of the redrawing. That is the position of the NAACP.
Well, in South Florida, I don't think there is simply one way to correct this. But
have you submitted an alternative plan that corrects it the way you think it should and keeps it more compact and neutral as far as partisanship?
We have not, Your Honor, but the example that was submitted by the coalition during the first consideration of this was a district that we feel better maintained black voting strength down there, was more compact than the invalidated one. But the Senate chose, despite choosing to go with the coalition's version or something similar, actually not exactly the same, but instead of going with the suggested version in South Florida, decided to go a different route. And interestingly, the coalition's suggested version would have taken the district into Hendry County and offered minority voters then the extra protection of being under the purview of Section 5 of the Voting Rights Act. But more importantly is the fact that racially polarized voting has to be a part of this analysis to determine whether black voters or Hispanic voters really do.
Well, if we accept that that's correct, at this stage, is it? You seem to say that the Senate, because they didn't consider it, those districts must fail. That's your? It's sort of like what I'm envisioning is, even though neither of these areas are Section 5 covered areas, that you're suggesting some kind of a pre-clearance review for these two districts? Is that the Senate was supposed to have performed?
Well, I think what this court is charged with doing is enforcing adherence to the constitutional requirement that there be no diminishment of the ability to elect, and especially in Senate District 9, based on the, I'll grant you, limited data available, it seems more likely that the ability to elect has been lost.
So are you asking us to go back to the original, down 100 miles of the state to reconfigure that district?
Well, I think that the African American voters in Jacksonville have lost the ability to elect, and certainly the African American voters in Volusia County and Daytona Beach are now stranded in districts that won't be responsive to their needs. It is not necessarily an all or nothing scenario, but
so
it may be.
You don't agree that the original, I don't remember what numbers they were, but the Jacksonville down was overly populated district?
No, Your Honor, it was not. I mean, was not a packed district to begin with. And in an area where the data demonstrates that there is racially polarized voting, that white Democrats will not support the black preferred candidate if that candidate is himself African American, then the number that we need to look at is not the percentage of Democrats that are in a general election that are African American, but first the percentage of voters who are black in a general election, which in the new Senate District 9 is only 40%, meaning it's mathematically impossible for them to have the ability to elect the candidate of their choice absent substantial white crossover voting. We have to look at that, and then we have to look at have they been able to elect the candidates of their choice in racially contested elections.
In the primary, though, don't they end up controlling the primary candidate?
Yes. And if there were no racially polarized voting, that might be enough. But what we've seen is that even if an African American candidate emerges out of the Democratic primary, white registered voters will not support that.
They'll vote Republican rather than support a black Democrat?
That's what we have a limited amount of data in front of us, and that's what it shows, that white voters...
Should the court, in establishing the jurisprudence that we're going to be following, for a long, long time, look to that senatorial election, which I don't believe you'd find anyone that would suggest that it was anything but the most unusual and different in the history of Florida, but that should be the prism through which this is going to be evaluated and also into the future?
No, Your Honor, the jurisprudence doesn't need to be linked to one particular election, but where objective indicators before this court indicate that
that's what I understood you relying on as the objective indicator.
Right. I think then there is a need for further analysis, but that the court cannot determine based on the evidence before it that the new district facially complies with the Tier 1 standard and that it does diminish. You cannot conclude that it doesn't diminish the ability to elect. Thank you, Your Honors.
We thank you. The court will now take a 10-minute recess.
All right.
afternoon. Before council proceeds, I do want to apologize for the delay in the proceedings. We may now proceed.
Thank you, Your Honor. Raul Cantero on behalf of the Florida Senate. I'm sitting here with Andy Bardos from the Florida Senate as well.
Speak up. Thanks.
I'd like to begin with what this proceeding is not about, because there were a lot of defects with our prior plan that the court identified, and we have remedied them. But I would like to go through what the court asked us to do and what we have done and what they have not objected to. The court first asked us to, or ordered us to redraw the 8 districts that Justice Pariente had identified, to conduct a functional analysis as to certain districts that we felt that we had said we needed to maintain in a certain configuration, to preserve the city of Lakeland if possible, and to adopt an incumbent neutral numbering scheme. As to most of those, there is now no dispute. The opponents do not contest changes to districts 1, 3, 29, or 30. They don't contest that we conducted a functional analysis. They don't contest the changes to the city of Lakeland, and they don't contest the random numbering system that we adopted.
Just a question on that numbering system. I know no one challenged it. You know, we went from one time where it's a consecutive numbering and it said it doesn't have to go, geographically. I know when it was being debated that there was concern about this lottery system, but there's nothing that has been brought before us to say that that was incumbent bias, correct?
At all. And in fact, Your Honor, there were 29 incumbents that would be subject to that. Of the 16 that had numbers that restrict their eligibility, 13 of them were Republican.
Well, of course, most of the Senate is Republican, so.
Yes, but only 3 were Democrats. So there's no allegation whatsoever, nor can there be that random system. And of course, even a random system can offer disjunctive results because it is random.
I'm just saying that, the present makeup of the Senate is 28 Republicans and 12 Democrats.
Yes. And they also contest some districts that were not changed, as Justice Pariente pointed out. These are, first, the districts that were changed were 6, 8, 9, 13, 21, 26, and 31. And we agree that they're able to contest those. And we think on the merits that they're valid, but we agree they're able to contest those. But then there are others, 8 of them, for which there were no changes or very minimal changes, and those are 7, 14, 17, 18, 19, 22, 32, and 39. And I think the reason it's so important in a situation like this, where the process is governed by the Constitution, is that we only get one strike in this kind of case. And that's why the court gave us the guidance that it gave us the first time, because it knew that if they invalidated districts the second time around, the court would have to redraw the districts. And I think everybody agrees that we don't want that, and the court doesn't want to do that unless it absolutely has to.
Is your view that District 14, that did flip some, is one of those that's contestable, or one that is not contestable?
One that is not contestable, Your Honor.
And share with me, there were no changes made at all to 14?
Yes, there were changes, but the only changes that were made was to comply with this court's mandate as to then District 10. If you recall, District 10 began to, and you'll see it to your left here, District 10 began to the west and had a very narrow passageway, right. And what we did was close off that passageway as the court instructed. But if you look at the 2 District 14s on before you here, other than that, they're virtually identical.
Well, there's no question they're similar, but not identical. But the point being is that you view that as not on the field of discussion.
Yes, Your Honor.
Okay.
That's correct.
Okay.
Because they have not objected to that small change that we made. They're objecting to the whole thing. They're saying that it's not compact. They could have said that before. They never said that. And this court, in its opinion, said it noted that no party had objected to District 14.
Okay. As to District 8,
yes, Your Honor.
How do you respond to the argument that's been made that the city of Daytona Beach was split in half, and thereby diluting black vote?
Well, Your Honor, first of all, they're correct that it is split in half. There's no minority-majority district in Daytona Beach. In fact, Mr. Smith conceded here, not on behalf of the NAACP, but on behalf of the coalition, that their objections are not about race. Their objections are about the politics of it. So there's a 10% of blacks within District 8. So there's no right under either the Constitution or Section 2 or Section 5, and there's no kind of vote dilution claim. So I think on that.
I thought the argument really is here not only that political, but that there is a lack of compactness here, and that there is no justification under the Tier 1 criteria for this lack of compactness.
Yeah, and let me address that, Your Honor. The configuration of District 8 has to do with the configuration of districts above District 8 and districts below District 8. If you think of a ball, when a ball gets squeezed from both sides, it becomes more elongated, and that's what happens in District 8. District 6 is more compact on our plan than in the alternative plans. So it's really a trade-off. Their District 8 is more compact, our District 6 is more compact. We kept 3 counties together in District 6. We also kept 3 counties together in District 7.
There is something, though, I want to ask about that split, because we really, and then we can go back to some of these other challenges. But on District 8, as it was brought to the attention of the legislature through Senator Smith, but it would be pretty apparent that Daytona Beach was being split, and this tail that had been this tail of Democratic interests, Palatka went into District 6, which is a very Republican district, and Daytona gets split. And they said, well, yeah, we could have started to look to split Clay County, but we've already split Volusia. Now, if I'm Volusia County, the fact that, well, we're split in 2, so it's okay to split us in 3? I mean, is there something about that? And again, we're looking at this as, let's be logical, that if a county is split 3 or 4 times, their ability as a county, which we said was an important thing, to elect a candidate of their choice is impeded. And that is a concern of mine, that they said, well, we're keeping Clay County whole, but really Clay County, in terms of any of where you split it, it's not the same as taking a county and splitting it one more time. So my concern is that District 8, you have 3 splits for Volusia, you've got 2 for Lake and 3 for Marion. It runs 90 miles, and it is at a 0.24 compactness. And so doesn't that, once those are true, which is that there's no, the political boundaries are not being followed, and that the compactness is low, then we've got to see where the justification is. And if the justification is, well, we just decided we don't want to split Clay County, is that the kind of justification that raises some question about the political motive?
Your Honor, I submit to you that when it comes to choosing whether to go with geographic and political boundaries and in which way to do it, that's precisely the kind of judgment call that the legislature is still able to make under this Constitution. To use a pun, this Constitution sets some boundaries for the legislature, but within those parameters, the legislature is still able to make discretionary calls.
Where's the pun?
I'm sorry?
You said to use
the pun is the boundaries. It sets boundaries.
I'll accept that one.
I won't try anymore.
No, I'm glad you... I thought it was going to be funny, that's all.
You should be used to not being funny. But and another judgment call is we split Daytona Beach, but we didn't split the city of Edgewater, which their plans split. That's exactly the kind of judgment call we should be able to make.
Here is do we look at all at the fact that when we said that there was a problem with this old District 6, that had this, went and about as racially gerrymandered, as close as you can racially gerrymander something. I mean, I shouldn't say that because I don't know the whole country, so let me stop that. But it looked pretty much like there was grabbing up of black Democratic areas as that went down that 100 miles. So, and we said that this idea...
They say it wasn't packed, though. The NAACP
well, I understand we've got an interesting division here about the, whether that was packed. I think that the court's opinion, though, in its concern, was that they were packing an awful lot of black Democratic districts that didn't need to be there. So if it ends up that you then draw districts in Northeast Florida to achieve the same exact Republican balance, and you take an area like Daytona Beach, which is overwhelmingly Democratic, and we said you don't have to split up, you don't have to bus, Democrats to get some kind of balance, but you look at this area where there is a natural packing effect of Democrats in Daytona, and then there's a decision by a Republican legislature to split that city as opposed to not split Republican Clay County. Do we just ignore that when there's, the other tier 2 requirements are not being met? How do we look at that?
Let me back up a second. What the Constitution now requires is neutrality and kind of a blindness to factors like incumbency and parties, so that when you are drawing a district, unlike what the coalition has done, you don't take a look at where the incumbents are and where the parties are, because you're not supposed to favor or disfavor. And so you don't look at that at all. And if you don't look at that at all and you draw the lines according to geographic and political boundaries, you make judgment calls, that's all the Constitution requires.
Are you saying these judgment calls don't... Whoever drew this has no idea when they make these judgment calls what political parties dominate in certain areas?
Your Honor, what I'm saying is that when they draw the maps, they're not looking at reds and blues. They're looking at counties. Yes, Your Honor.
Okay.
And whenever...
Right in the middle of the black community in Daytona.
Your Honor, that...
Democratic black community.
That black community is not a majority, minority, or even an influence district. It's a 10% minority community.
But what about political parties?
And political parties, District 8 voted for Obama.
I know, but...
So it's a very competitive district. And as the prior court's opinion said, when you draw these districts, there are going to be political consequences.
Of course.
But the Constitution does not prohibit adverse effects. It prohibits adverse intent.
Mr. Cantero, from an academic standpoint, if we don't have the majority-minority districts, we don't have influence, what you're saying, how would you articulate with regard to consideration of racial issues, ethnic issues, as we go forward in drawing these lines, because that's what these decisions will do?
Well, I think that under the Constitution, when there is a certain percentage of minorities in a district that can either constitute a majority or a coalition, under Section 5, for example, that is not enough to constitute a Section 5 issue. It's only when you can actually elect the candidate of that minority's choice. So we think that happens in Dade County. It happens in District 9, for example. That would be a protected district because they have elected candidates of their choice. It would happen in District 19, but it would not happen.
What about District 9? Let's go back to that one, because now we hear from the NAACP that the newly drawn, that District 9 is the Jacksonville district,
yes,
right?
Your Honor. Yes.
That the newly drawn Jacksonville district now has diluted that minority voting ability, and now they no longer have that ability.
Your Honor, I don't think that's exactly the NAACP's argument. The NAACP's argument is more, we can't be sure. They're not saying it was diluted. They're saying we're worried that it may be, but we don't have any evidence that it is. And in fact, I've never seen a case in my life where somebody gets reversed for doing exactly what the court told it to do. And this is exactly what this court told us to do. It said that District 6 was invalid, and it said we like the coalition's District 1, from their prior plan, and the court actually conducted the functional analysis on that district, and that ended up with a black voting age population of 42.4%. Ours is 43, and the court said that it conducted the analysis and said despite the fact that the voting age population is reduced, blacks will still be able to elect a minority of their choice. And in fact, they just elected a black mayor in Jacksonville. So we did as the court instructed on District 9, and now for the NAACP to come back now and say, no, revert to the prior plan. They didn't come here last time and support our plan. They stayed in the background, they issued a comment, but they didn't say we need District 6 the way it is. They could have said that.
Here's it's a concern, and it's really what, as we go forward, about how we make sure that the state is, we can't have perfection. And you said it has to be blind. And so, I don't know if we all closed our eyes to the colors of the black, white, red, blue, whether the state would still end up where you'd have the kind of imbalance that we have in the Senate now, which may be certainly the effect of what happened in 2002. That is an overwhelming number of Republicans, even though the state is not overwhelming Republicans. So my question, going back to this district, is that you're correct.
I'm sorry, which district are you talking about?
I'm back up to the Northeast Florida
to
area.
District 8?
Well, I'm going to start with the district we were just talking about. What is it, District 9? 9. Is that when we said that there was, that the reasons that the Senate offered, which was they wanted to make sure this was a black opportunity district?
It's a black performing district. There's
black performing district that we said it can still occur. Did the Senate read that as that they should just forget about the rest of the coalition plan that kept Daytona Beach together and made that whole area more competitive for Democrats? I mean, and in fairness, I mean, obviously you're not there to be doing it, but my concern is that it appears that the court was looking at the packing, not under Section 2 or 5, but the packing effect of taking all the blacks out of the surrounding areas and saying, they have more, we give them more credit that the blacks in those areas can have some influence in their naturally occurring districts. But instead now we've got Daytona Beach, which had been part of the end of the tail, being split where 2/3 of the black population is up in District 6, which is a solidly Republican area, and that if they're put with District 8, even though it doesn't significantly change the Democratic performance, it does switch it, and it does give the Daytona Beach an ability to be of significance in that district. Now, is that totally just, you say, that's just policy, that's not, if you were in, if you were in the Senate, you could have made that decision, but it's totally okay, we made the decision to keep Clay County whole? Does it fall into that same exact, it's a policy choice of the legislature?
Your Honor, respectfully, I think it is. Once you don't have the racial overtones in that it's a majority-minority district that needs to be protected, and I think the other side will agree that there is no constitutional directive to keep that, to have any kind of black majority or coalition district in that area. What we're missing here is that our District 6 is more compact than their District 6. So we are complying with the Constitution as to District 6, whereas they are intentionally not complying. They can't argue that it's more compact than ours. They have a more compact 8. We have a more compact 6. There's a dozen ways or more to draw a plan.
But when you did, and this is the consistency argument, which is that Senator Thrasher pointed out when it got to Plant City, where somebody says, listen, Plant City should be with Hillsborough. And they went at great length, and they designed a district that they made choices, and they put Plant City with Hillsborough. And Senator Thrasher said, well, when you're doing that, you're really taking Plant City, where you say the mayor called you, and you're giving that credit, but you didn't do a similar thing when it came to Volusia and Daytona Beach. What is your...
Well,
so there's that issue of consistency.
The consistency is that by acceding to the requests of Plant City, we actually made that district more compact, not less compact.
Now, the district being...
district being 24.
So, but you're saying we only look at 6 and 8, and I think when Mr. Guthrie talked about this with Senator Smith, he said it's a global look. You don't just look at these two districts. You've got to look at the area. And if you do the area, you end up where if Putnam is placed with District 7 and Clay with District 6, you make that area overall more compact and more competitive.
Well, I disagree with that statement, because Putnam is now with District 6, and District 6 is more compact. Our District 6 is more compact than theirs. And District 7 is one of those that the court didn't order us to touch, and so we didn't touch, and there's no reason to touch it because it is 3 whole counties and nothing more, which is, you can't ask for more than that in a redistricting where you just have 3 whole counties. And of course, that may affect the compactness of the district, as this court said in its opinion, but it still complies with the geometric and political boundaries, and those are trade-offs that the legislature is allowed to make. We made the same trade-off in District 10 and 13, which is below District 8, where District 13 cuts on a county boundary, and we kept District 10 all within Seminole County instead of splitting Seminole County, which is what they do. Again, it's a matter of trade-offs. A lot of this is you can always make a better plan, and you can always look at something and attack it from all sides. But that's not the purpose of this court. The purpose of this court is to determine whether our plan is valid or not, and we deserve some deference within the boundaries, within the parameters of what we have to do to make certain judgment calls. And I think that's what we did. Unless the court has any further questions, I don't intend to take an hour.
We love to hear that. I just want to ask you about.
I thought you'd like that.
District, the 30, just going back to this, the preclusive effect. You use the term res judicata, and obviously we all know that has a very.
We don't need to go with that term, Your Honor.
You think it's.
Let's go with fundamental fairness.
Okay, I like fundamental fairness.
Because of the way the Constitution's written. We go back, and then if we made a mistake, we don't get to go back again.
Right. Okay, so on this, and that's what for this District 32 that was District 25.
Correct.
What they're saying is that it's now, whether it was attacked or not, it's the identical argument as Districts 1 and 3. Is it the identical
Your Honor,
argument?
As to District 32, I think their problem is even worse than with other districts as far as the preclusive effects of this court order. They specifically contested District 25. And this court specifically said 25 is fine, 25 is valid. So how are we going to change something that they contested and this court specifically said was valid?
Did you feel that the Senate feel that by saying that Lakeland should be looked at, that they were mandated to redraw and put Lakeland whole?
I think that the Senate felt that the Florida Supreme Court asked us to look at something. Let's look at it and let's change it if we can change it. I have to tell you that the Senate was very cognizant of the constitutional issues here and very cognizant that if this court invalidated this second plan, that plan was now out of its control and this court was going to draw the districts. And the Senate took its business very seriously. And if you look at the 2 plans before you, I think that you will agree with me that the second plan, as far as the districts that you've invalidated, looks nothing like the one that you invalidated. and we did exactly what this court asked us to do, and therefore our plan should be upheld. Thank you for your time.
Just a couple of quick points, Your Honor. On the point about blindness to neutrality, I fully agree with Justice Cantero that that is the way that the process ought to work. But this court also needs to police that process and not just simply take the Senate's word for it. And I think what you have is the reality that any one line may well be by itself not subject to attack. You have to look at the overall pattern sometimes. And if calls are made time after time in an entire region of the state so that every single district ends up below 45% Democratic performance, when there are equally good other ways to do it to keep counties together, as we've demonstrated.
They say, though, that District 7, which was not challenged last time, to really make this, I would say that looking at the plans, to make this region work, District 7 has to be altered. And they're saying because this maybe, and they're not saying it this way, but if this was first time around, if this was now the round one, that there maybe are problems that could be addressed, and then they could address it and make some other choices. But why wasn't it a legitimate policy choice to keep 7 undisturbed?
Well, Your Honor, there were many districts that they changed that were not previously challenged in the course of fixing the problems that this court found. There's nothing sacrosanct about District 7 as opposed to all the other districts that were changed in the course of fixing the problems this court identified. And if it's the right way to fix the District 6 problem that they created, the old gerrymandered district, if the best way to do it happens to include moving Clay County from 7 to 6, there's nothing that suggests that that is any different from all the other changes that they made throughout the state. So I don't see anything particularly persuasive about that point.
What about this issue, and I think where do we put the idea that, again, keeping a county whole, but then ending up splitting a county 3 ways? What is how do we look at that jurisprudentially?
Well, Your Honor, I agree that there's something more serious about carving a county up multiple times. I think everybody's map does that sometimes, but it is something that will make that county have an even lesser sense of representation in the legislature if no one district is even a majority of it in that county, if it could be done that way.
Is somebody going to respond to the NAACP's argument about...
That was my next move, Your Honor. I do think it's important to recognize that this supposed risk that the courts created here occurs by virtue of creating in Duval County a district in which 67% of the registered Democrats are African American. And a district that is overwhelmingly Democratic, elected in all recent elections. This district, if you plug the results into this district, it's overwhelming. The Democratic candidate, black or white, wins. And we have...
And this is 9 we're talking about.
Yes, Your Honor, I'm sorry.
67.
67% of the Democrats in the district are black. African American, yes. So this is not a question of having any issue with the primary, and I don't even think Ms. Riggs really contested that. Her argument seemed to be that in the general, if the Democrats are so foolhardy as to nominate an African-American nominee, they won't, the white Democrats won't support that person. And I don't know what the basis for that is. You have this obviously crazy election in 2010 in the Senate race where the sitting governor is siphoning off Democratic votes because everybody thought he had a better chance to win, and by the end, Mr. Meek. That doesn't tell you anything about how a normal performing district will perform. And you have Duval County, where this district is, and another district, which is the least favorable parts of Duval County. They sit side by side. Putting them together, they have just elected an African-American Democrat in an off-year election, not in the Obama year. So to suggest that the best half of Duval County will not give an ability to elect just doesn't make sense given the history in this area. What you see with the NAACP is one of 2 mistakes. Either they're demanding a certainty of election no matter what, even in a situation where the governor decides to run as an independent, or they're saying any reduction in the percentage is a violation, which is not the law, certainly not under the DOJ guidance, which this court made the authoritative statement about how to interpret retrogression. Thank you, Your Honor.
Thank
you. May it please the Court, I'd like to try to respond to three issues that were raised. Justice Lewis, you raised the issue about whether District 14 had changed. It seems to me if this Court is to impose on the process a prior decision, it can't make a district not contestable. You may find it's valid. You, of course, can review it. But to say it's not contestable when they changed it, how can you do that? You have to look at what they did. Did they do it right or wrong? If you told them to do something, you have to look at it.
Well, what about on this District 32?
32?
They say that we rejected the challenge, and I think we talked about, let's just make sure that we rejected the same challenge that is being made even at the time that we took the panhandle. And just let me finish my question. Just at the same time that we said, no, you couldn't do it up in the panhandle.
You said you couldn't do it up in the panhandle. And the issue in District 25 was you told us we didn't submit a map. That's new rules. I mean, that was something that is a way to declare a district invalid, so we learned, we submitted a map. And it is the least compact district, so by the test that you provide, you look and see if it's visually compact, if it's statistically compact, and if there's a justification.
How many, in your alternative, if you invalidate District 32, how many other districts are affected?
I think one other district is we don't statistically change anything that would relate to race or any of the other areas. And if I may, I'd like to further respond to Justice Lewis's question on 14. They've suggested on page 34, I believe, of their brief, that they did a functional analysis, and they referred to where they did it later on page 54. And they did sort of what was suggested that the NAACP might be requiring. They suggested that the test was you had to show you could elect a Hispanic, not a candidate that was a choice of Hispanics, and that's on page 54. And I don't think that's a functional analysis that looks at the Constitution. So the issue then being that is a very non-compact district. It was changed. So you simply need to apply your test. And on District 8, the way there are a significant number of splits. You need to look at District 8, and what you have said is if it is non-compact, what's the justification? It's clearly not race. I mean, there are arguments that it's worse than it was. There are no arguments that it's better. There are no Tier 1 justifications for 8.
Would you respond to the Senate's position that with regard to District 8, that we're not dealing with a majority-minority situation, we're not dealing with a protected or a performing kind of numbers we're talking about, and as I understood the argument is that race and ethnic makeup just has nothing to do with the academic discussion or the practical application of these lines.
It should have something to do with the discussion and the practical application. I believe their position is that there's no Section 2 or Section 5 requirement to build a minority district.
Well, I understood that too, but
that's
again,
all I understood.
Well, I understood that.
Okay.
I understood what you're saying because it seems to me that if it is part of the discussion, then we need to address it.
Yeah.
If it's not, I mean, we know its status with regard to the legal status.
Well, they divided an area, they divided a city, they divided a minority population when there was a clear option to do otherwise. So The question is, given all of that, clearly no justification for minority purposes, and because of its compactness, it is politically suspect. So you have to look at District 8 and try to find a justification.
Well, but again, if it comes down to other cities, and the Senate mentions that there are others under other plans that will dissect other cities. So if the racial or cultural background of the people of that area are not part of the discussion, why is it different in Daytona than it would be for the other cities that are split?
Which is relevant anywhere. But
I understand that, but more relevant here. I mean,
it's very relevant here because it happened.
Well, I understand that with Lakeland the last time around.
Right.
But again, I think it takes one added emphasis if there's a different level of discussion. And I think you understand what I'm saying.
It takes an added emphasis because of the racial issue in the clear absence of justification. So,
is there? As I understood the plans, are there less cities split under the alternative plans?
Well, there are clearly less counties split.
Right.
There are far less counties. And
but is there a trade-off? Is there one more by not splitting Daytona? Does the coalition split another?
I am not aware of
Florida
additional city splits that are as significant as Daytona's effect.
Well, I mean, that's understood. But the question is taking out some of those factors. That's the question. Are those factors relevant to the discussion of the splitting of the city? I think that's what it really comes down to.
Yes, sir.
So your answer is yes, it is.
Yes.
Okay, and we have really no jurisprudence that addresses that at this point, though.
No.
Okay.
Well, if there's so let's follow up on what Justice Lewis is asking. So if there's no jurisprudence, and I think I asked you last time, well, if you were writing this opinion, what would you say? So the question is if we look and say, is it the same exact thing than if Daytona Beach was an all-white Republican city? Then does it race matters, or is it the party that matters?
I think you can say race matters because race is mentioned in the Constitution, and you can determine that was a more serious decision than perhaps splitting another city. But you understood where they drew the line, and I agree with where they drew the line. It's not irrelevant; it's relevant, but it doesn't compel the drawing of the district. And we would also say that District 9 as drawn is valid. And in conclusion, Your Honor, this court made an enormous effort to draft a thorough and comprehensive district to set out standards for a very important 10-year future of Florida. And it's very important that the court have the opportunity to finish the business by reviewing the validity of every district. This court is well qualified with the technology available. The best result is for this court to do it. If this court determines there are invalid districts anywhere,
well, you would
this
agree.
court would
Even
restore
if we decided that one district was invalid, nobody would suggest that the whole map should be withdrawn. You're not even
not suggesting you withdraw the whole map. You would respond to what you thought the validity issues were. There's no constitutional limitation, but pragmatically, you do what you have to do based on those things that are invalid.
In exercising restraint, it would have to be the way to do it.
Yes. Thank you.
We thank you all for your arguments. Court is now adjourned.
All rise.